Hi, you're about to go into a deposition, and I'd like to speak to you a little bit about what a deposition is and why it's necessary to do, and what you should know and not know with regard to this process. A deposition is nothing more than a question and answer session. However, we can speak at any time. I can call you, you could call me, we see each other, we talk, we can do emails, we can have conversations at any time regarding your case. However, by court rule, the other side, the party we're making the claim against, only has one opportunity to speak to you and ask you questions, and that's by deposition. They can ask you questions in writing, which are called interrogatories, which you already did, but speaking to you and asking you questions is a deposition, and that's the only process they're allowed. It's informal, it's done in the office, it's with a court reporter, a stenographer, who will take down everything that's said. Now keep in mind, the court reporter can only take down one person at a time. So you have to be conscious not to speak until the other side has spoken and finished speaking. Then you would provide your answer. A few ground rules. Listen to the question. That's very important. If you don't understand the question, you need to say that. If you're a little bit unsure what's being asked, you need to say that. It's not your job to interpret the question. It's the attorney's job to ask a clear and concise question. So if there's any confusion in your mind as to what's being asked, you need to let us know so that we could clear it up. If I or one of the attorneys in the office on your behalf, and we will be there with you, we don't allow you to go in there alone, if we start to speak, you need to stop speaking. And once again, the reason is twofold. One, the court reporter can only take down one person at a time. And two, and more importantly, we may have an objection or a concern about what is being asked or what's being done at that point in time. What I would like to impress upon you as well is listen to the question. It's human nature for people to want to talk. But in this setting, again, listen to the question and only answer what the question requires. One of the most common examples I give is if they were to ask you, did you have breakfast today? Most people start to talk and say, oh yes, I went to the diner, I had breakfast with my friend Jerry, I had eggs, then we went to the mall afterwards, and then I went to play some golf. That's not the question. The question is a simple yes or no question. Did you have breakfast today? It's yes or no. Further detail is not required because it's not being asked. So the point I'm making is listen to the question, only answer and provide what the question requires. Don't go beyond that. Keep in mind, as I stated, the court reporter takes down everything, and you have to wait till the other side's done talking before you start talking. Again, if you don't understand the question, you let us know, and we'll do what we can to clear it up. If I speak, you stop speaking. Listen to the question. Only answer what the question requires. There will be someone from the office with you there. So don't worry, we're here to help you with this process. Just be comfortable, be relaxed, provide the answers to the questions that are being asked. There will be someone from the office with you there. So don't worry, we're here to help you with this process. Just be comfortable, be relaxed, provide the answers to the questions that are being asked.